I'm recording this because I want to share with people the challenges, the difficulties that you will have as a pro se litigant when you go to court. And pro se litigant is somebody that does not have a lawyer, basically an unrepresented person. And from one unrepresented litigant party to another, you're at a disadvantage when it comes to the court system. And just walk in knowing that. But just because you walk in with that disadvantage, right? You walk in with judges don't like pro se litigants, lawyers don't like pro se litigants. And the reason why they don't like pro se litigants is because they're walking into an environment where they don't know how things work. And even if you were an attorney, the judge would admonish you. Like, let's say you had an attorney and your attorney did something. The judge would admonish the attorney, but it wouldn't have this undertone of, you shouldn't be in here. So you could do the same exact thing as an attorney, but there's not that undertone of, but you could do make the same exact mistake as an attorney, but there's this undertone of, you shouldn't be here, because the judge will say, this is why you have an attorney. As if an attorney is going to know all the rules, all the procedures, and all the nuances of your case, of instituting your case. Now, for me, I was just recently a pro se litigant I was a plaintiff, so I was the one bringing the lawsuit, filing the lawsuit. I was a plaintiff in a childhood sexual assault case that occurred where I was the victim. And I filed the case in Los Angeles Superior Court. I ran into so many challenges with that case, and some of the things that you will run into. And one of the challenges, like right here, you see this? This is my case file, right? This is my case file. The case file is where all your documents basically go. Everything that you filed, everything that the opposition filed, emails. Let's see, what do I have here? What do I have here? I have everything that I filed. I have the list of filings, emails, no further orders of the court, all those things I had in here, right? In my case file, right? And as you'll see, it's got tabs. That's just one part of getting ready for trial, because you have everything that you do pre-trial, and then you have everything that you have to do during trial. You look at everything that you have as getting ready for trial. Everything that you have is preparation for trial. And the more prepared that you are for trial, the more confident and assertive you will be, and the better likelihood you will have of success in court. Now, me, I'm living in Louisiana. I'm living in Seattle, Washington, and trying to file a case in Los Angeles, California, and not being down in Los Angeles, California, so that I can file my documents, talk to the clerk, and things like that. So already right there ran into problems. And one of the problems that I ran into was not having the right documentation, not having the right forms in order to file my lawsuit. And there's an interesting argument in that, of trying to file your documents and the clerk not accepting your documents. But before I get to that, I want to talk about first identifying does the court that you're filing in, do they allow for e-file? Because there's clerk's offices that accept filings by mail, right? And you got to pay for that, knowing how much to pay and all those things, right? Those are all things that go into just starting your lawsuit. Like, we haven't even talked about the fact of writing up your lawsuit and those kinds of things, right? We haven't even talked about that. I'm just talking about the process. And so I want people to understand there's the content, and then there's the process. So you can have all the content right, but get the process wrong. And because the process is wrong, that invalidates all the content. Those are the things that people just aren't prepared for when they are walking in as a pro se litigant. And I have the advantage of understanding as a lawyer, understanding that there's a process for something and knowing how to look for these particular things. I ran into a situation where, all right, I got my lawsuit, I have all my papers ready to go, and the court or the court's clerk rejected my filings. That is one of the most frustrating experiences of paying all the money and then to find out that the clerk rejected your filings. One of the things that the LA County clerk has been good at is telling you why they rejected your filing. But those are things that I ran into. And every now and then, what I had to do was write a declaration and basically utilize federal law of saying that under 18 USC section 2071, it is a crime if the clerk refuses to file paperwork seeking remedy and redress in an effort to conceal facts. 18 USC 2071 says whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, or with intent to do so, takes and carries away any recording, proceeding, map, or deposit with any clerk or officer or of court of the United States or in any public office or with any judicial or public officer of the United States shall be fined, right? I had to utilize those things as basically like a threat of, hey, I don't care if it's not necessarily if I'm utilizing the wrong form, file my document. The forms only make it easier for you to understand what I'm trying to do, but I'm trying to get my lawsuit in. So the biggest challenges are for pro se litigants, and it's having your filings rejected. And then two, not having the proper forms that are needed. And three, proof of service. And the reason why proof of service is so important is because at least with LA County, you can utilize a proof of service form, but then it's like trying to fill it out correctly versus what most lawyers do is they already have their own proof of service form that's attached to whatever filing that they make. And so when they make the filing, they're also filing the proof of service as well at the same time. You'll file the document and you're like, okay, I'm not going to fill out the proof of service until I've actually done it. And then I'll file the proof of service. No, 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 no. Don't make the mistake of having your papers and filing your proof of service separately. What I did is the moment that I was getting ready to file with the court is I grabbed an envelope, filled out whatever envelope, handed it to my wife, told her what information needed to be put on there and put a stamp on it and had her send it. So when I filed and I had her sign the proof of service, so that way my stuff, when I filed my document, the proof of service was also filed with it. Point blank period. So then that way I eliminated that extra step of having to send it, then filing it with the court, you were e-filing it with the court, waiting for a proof of service to be done, and then filing a proof of service with the court afterwards. You will save yourself a bunch of headache, right? Whenever you make the document, whatever filing that you have, because you always have to give the other side a copy of whatever you file with the court. General rule of thumb, you always have to provide the other side with a copy of whatever you give to the court. There's your copy, the court's copy, the copy that you send to the opposing party. And then there's something that we called a conformed copy, which is the original. There's the copy that you send to the court. There's the copy that you send to the other party. And then there's the copy that you receive from the court that is stamped. That is called a conformed copy. That right there lets you know that your document has been accepted by the court. That is so critical. And whenever you are building your folder, right? Your folder, you see that right there? That filing stamp? That's what you want. This is what's called a conformed copy. That says, hey, my record and the court's record are the same. And that's what you want, is your record and the court's record being the same. So your copy, the conformed copy, the part that you give to the court, to the clerk, and the part that you give to the other party. So now Like I said, everything that we do is in preparation for trial. Everything that we do, you're going to have motions, you're going to have discovery requests. One of the most important things is always respond to papers that you receive from the other party. Always have a response. Always have a response. If there's something that you don't agree with or something that's not true, always make sure that you address it. What I want to show you something right here is what it looks like when your filing gets rejected. Rejected filing, right? One of the most aggravating things that takes you off, because with the court, you're working on deadlines, you're working on time delays, you're trying to take advantage of deadlines and things like that. And if the clerk doesn't accept your things, then you run into trouble. And one of the things that I ran into was that I was trying to get a default and the clerk rejected my filing for default. And I didn't understand why, right? I could have went to a lawyer about it, but I was like, you know what? I could have went to a lawyer about it to figure that out. But by the time that I was able to get all that stuff squared away, was the opposition had already responded, So everything that you do is in preparation for trial. The more prepared and more organized that you are before trial, the more prepared that you are going to be for trial, point blank and period. Now, what we have to understand is that just because you did wrong, you still have to prove it. And what does that mean? That means that in every cause of action means there is a law, a rule that says that you are entitled to recovery. There's a law or rule that governs somebody's conduct, and you're trying to show that they violated that conduct, right? There's elements. Every law has what we call elements, and elements are proven through facts, and those facts are supported by evidence. So, like in my case, it was brought under the cause of action was childhood sexual assault, which is California Civil Code of Procedure, Section 340.1. And in order to be found guilty or to be found liable of it, you have to perform one of these acts that is defined as childhood sexual assault. One of those things was Penal Code Section 287, which is oral copulation. What makes it childhood sexual assault is if you perform oral copulation on a minor, right? So I had to prove that I was a minor. I had to prove that there was oral sex that occurred between me and my attacker. And so those are the elements that proving that I was under 18, proving that the actual conduct actually occurred. So those are the elements that I have to show, that I have to meet, that I have to demonstrate. What are the facts that support that, right? The fact I have to show that I was 18. I have to show that happened. How do I show that? How do I meet those elements? By providing a bunch of evidence that makes those things more likely true than not. That's what we call the preponderance of the evidence. And that's important in civil cases because most civil cases are by a preponderance of the evidence, which means that it's more likely true than not. Whereas in criminal cases, the burden of proof is called beyond a reasonable doubt. So in civil cases, it's a lower burden of proof, preponderance of evidence, meaning that it's more likely true than not. So meaning that it's 51% true and 51% chance of being true versus a 49% chance of being untrue. What I showed is that in my case, it was more likely to be true than it was not true that oral sex occurred on me while I was still a minor by Ms. Crystal Evans Park. But I had to have a bunch of evidence to be able to prove that. And what is the evidence that I used? I had probably about 12 to 15 different exhibits, right? 12 to 15 different exhibits. I had chats, a bunch of chats. I had a bunch of pictures. I had a bunch of communications that would show, hey, that there was a relationship that occurred, that we knew each other, that we were talking about sex, that we were interested in each other, that she was interested in me, that This is where we would go and do it. I'm providing a narrative. I'm providing facts, right? And I'm supporting those facts or that fact pattern or that narrative with this evidence. Hey, there was a relationship. Here's showing the continual contact between the two of us. And which brings us into a critical part of like being a good lawyer is understanding evidence. That's what makes a good versus a great lawyer is somebody who understands evidence. Somebody who understands how to get evidence in, how to use that evidence, and how to exclude evidence. So critical. What evidence can be used for and what evidence can't be used for. Understanding the hearsay rules and hearsay exceptions, all of those things, because your evidence is the meat and potatoes of your case. You might have all the narrative and all the evidence to prove your case, but if you can't get your evidence in, if you can't show how your evidence is relevant to the case, it's going to be very difficult to get it in. So evidence is anything that is offered to prove the truth of the matter asserted, the truth of the matter of the fact asserted, right? Offered to prove the truth of the matter asserted. Or the phrase offered to prove the truth of the matter asserted is a central concept in the legal rule against hearsay. The legal definition of evidence is an item or information proffered to make the existence of a fact more or less probable. An item or information proffered to make the existence of a fact more or less probable. So I'm taking evidence and I'm trying to show that the fact that I'm trying to prove that there was oral sex that occurred, I need to offer evidence that makes the existence of that fact more probable than not. These are the things that people don't understand of all the preparation that goes into just trying to make your case. You ain't even argued it, right? You ain't even argued it. For cases and things like that, you will go through a discovery process, right? The discovery process is where both parties start collecting their evidence and both parties start identifying what is the evidence that is going to be used against me. What is the evidence that's going to be used against me? And from the evidence that is given, you can start to identify what the other side's strategy is going to be. It's very important to know what the evidence that people are going to use against you, right? And then understanding that not all the evidence is relevant. What is relevant, right? Relevant evidence, right? Rule 401 of the Federal Rules of Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without evidence, and the fact is of consequence in determining the action. It's a very loose definition. Once again, when you're in there arguing a case, understanding, hey, here's all my evidence. This is what I'm trying to prove. And I'm trying to get as much of my evidence in and show how the evidence is relevant to whatever it is that I'm trying to prove, and that I need this to be proven so that I can demonstrate that the elements have been met. The reason why lawyers get paid a lot of money is because there's a lot of preparation that goes into it. But you as a pro se litigant, if you start to understand the process, start to understand the things that you need, then you have a higher chance of success, even going against lawyers. One of the things that you will have when you get ready for trial, like I said, you filed motions, all that stuff, you're going back and forth. That's basically legal paperwork that's going between the two parties that's fighting each other, right? You're fighting each other through paper. Then you say, all right, well, we've gotten to the discovery process. Here's all of my evidence that I'm collecting, I plan on presenting, all those things, right? Both parties have to have a copy of the evidence, right? That's called discovery. So whether that's depositions, whether it's text messages, you do not want to go in there with surprise evidence day of court. The court doesn't really like that. But you have all your evidence. There's something called a trial binder. Your trial binder is what you prepare where you have all your evidence that has now been put into exhibits. So it makes it easier for you to reference your evidence, makes it easier for the court to see what evidence that you're providing, makes it easier for the other party, makes it easier for any witnesses to be able to follow, and most of all, makes it easier for you to organize and go through your case and present your case. How clearly can I present my case? That's what you need. And those were some of the challenges that I ran into, because the court is going to want their stuff in a particular format, and give it to them in their particular format. You're going to have hard enough time trying to prove your case and make your case that you don't need any other stumbling blocks or pissing off the judge, right? But being a pro se litigant isn't impossible. There are barriers and there are challenges, but I will say that the only way that you get better at those things is through experience. Over this past year, I have filed suit against child support. I've filed suit. I filed contempt hearings. I filed motions for contempt. This I need to appeal, as a matter of fact. I filed a lawsuit against my landlord. I filed a bunch of lawsuits, and I've been successful in a couple of them. But you learn, right? I've had to learn Washington's law. I've had to learn Louisiana's law. I've had to learn California law, right? But it's not impossible. It's now taking your time to doing your research and being diligent. And now with things like AI, I wouldn't recommend a pro se litigant just automatically use AI, but I will say that AI is very helpful to somebody like myself that understands what needs to be in a lawsuit when it comes to responding to motions, responding. Like I said, utilizing AI is very helpful to somebody like myself that understands the process, understands how the law works, understands kind of the form of things, how they need to be presented. But AI will lie to you. AI will miss things. And that's why it's very important that anything that you do with AI, that you literally read it over and review it. Because what will AI do? AI will cite cases that aren't even real. That's one. That's called a hallucination. Most people think it's a bug. I think it's actually a feature, because you're asking for it to generate something. But AI can have a challenge of knowing what's real and what's not. So depending on which model that you're using, right, that's something to look at. So AI will spit out fake cases. I've had AI where it spit out a real case, but it gave me the wrong citation. I've had it make the wrong conclusions about what a case was when I asked it to summarize a case. I've had AI miss critical elements that I needed to argue, right? This is why if you're going to use AI in your lawsuits, it's really going down and treating the AI a dumb law student or a newly graduated paralegal. Like, you're there to help lighten my workload and do a lot of the repetitive and some of the heavy lifting. But I recognize that there's certain parts that you might put it on there, but it's, at the end of the day, a lot of lawyers have gotten in trouble for using AI in their cases and not checking it. You don't want to be one of those people. So, like I said, being a pro se litigant, and this is stuff that I've learned over the last, I don't know, maybe 18 years of being a pro se litigant, where I have represented myself successfully in a probation termination hearing back in 2012, maybe 2013. I've represented myself successfully in those things. I represented myself successfully in child custody hearings before. And then when I got a lawyer, it became even better, because where it messed me up was dealing with child support. I thought I could do it as a pro se litigant in child support. Hell no. Not until you actually learn the law, things like that. You can have success as a pro se litigant, but there's a lot of diligence, and you see why you pay lawyers, because litigation takes up a lot of your time and a lot of your energy. And once again, they say that the person that represents themselves has a fool for a client. And the reason why that is because being emotionally involved in a case will cause you to lose things. It will cause you to lose objectivity and sometimes lose perspective, which can be difficult, right? Which is why you sometimes need to bounce your case off of people who are lawyers, or why you need to go and talk to a lawyer and, spend $250 for an hour of a lawyer's time to explain your case and things like that and get some legal advice from them, right? Being a pro se litigant is challenging, but it's not impossible. You can win as a pro se litigant, and I've watched people go and do it. And court can be a very scary thing. It can be a very intimidating thing. But the more prepared that you are, the more assertive that you are of like, hey, this is what it is. The judge may not like it. The judge may be annoyed, but guess what? It's not about him being annoyed. It's about you exercising your rights, because the only rights you have are the ones that you exercise. Final little thoughts. If you don't agree to something, object it and make sure that it's on the record so that you preserve your objection for the record when you want to appeal. Because the court is going to be like, well, why you didn't object to it? And you're like, well, I didn't know how to object to it. I just thought it was being done wrong. You have to show that you have a problem with it. It's things like that. Those are things that they don't necessarily teach you, but it's things that you learn. And that's why they call it the practice of law. So I hope that helped. And go out there and be successful. There's a lot that you can do with the law. I became a lawyer because of all the legal situations. I went to law school because of the whole situation with my daughter. It's crazy how the things that you run from are the things that you end up running towards. And if you run from things, you end up taking the long way to get there. Point blank, period. So hope that's been helpful. I woke up in the middle of the night and I was like, let me go ahead and get this out. So y'all be blessed. It's Dr. Jamar Montgomery here as a successful pro se litigant. And hopefully this helps y'all. Y'all take care.